Just to tell you briefly what transpired in court this afternoon. You saw that the matter today was actually adjourned for the court to deliver its ruling on the application that was earlier filed by the defendant. What is the content of that application? That the court should vacate its earlier order that the court made so that the defendant can be tried in absentia. And we oppose that application, that particular application is dead upon arrival. Why is it dead upon arrival? The person that jumped bail, and then the security forces were able to bring him back to face his trial, then there will be no need for that application because the application has been overtaken by events. He's physically there, and then let's continue with the trial. So the court agreed with us, and of course, completely strike out the application and dismiss it, paving way for us to go into the trial of the case. Again, they filed another application. What is the content of this other application they brought? The application, in essence, is asking for the court to grant an order of staying further proceedings of the case pending the determination of the appeal that they filed, challenging the counts that the court have retained to try the defendant upon. And then we say, no, you can't bring such an application. The application is stopped. You are stopped from bringing such an application by the operation of Section 306 of the Administration of Criminal Justice Act. That particular provision expressly, unequivocably says that no court, no trial court, should grant an order of stay of criminal proceedings pending the determination of appeal. Because we don't know how long you are going to be on the appeal. So why stay the proceeding, especially in a case such as this one, that is brought under the fast-track proceedings, under the Federal High Court Practice Direction of 2013, which clearly says that the matters of this nature must be tried day to day, so that the matter will be dispensed with, the defendant knows his fate, the complainant knows his fate. But unfortunately, they brought the application, and the court of law must take the application one way or the other and dispose of it. We said no. If you are ready to move your application, move your application. We have our counter, we have filed the counter. Today, they decided again to withdraw that particular application, having tested the waters. That particular application will not fly because of the operation of the copious provision of Section 306 of the Administration of Criminal Justice Act, especially when read alongside with Section 392 of the Administration of Criminal Justice Act. So, essentially, that is what transpired today. And they have insisted that, no, they have filed appeal and that they've entered the notice of appeal. They've also have filed application for accelerated hearing of the appeal. So the court should grant them that stay. The court said, okay, fine. If you want us to grant, we cannot grant the stay for you in the light of Section 306. He said, no, they are going to test that Section 306. Go to Court of Appeal. But this court cannot grant you that order. And that is exactly what happened today. And that is why the matter was adjourned today to November 14th in order to allow annual court vacation. You know, of course, you know that the court is proceeding on this annual vacation. So we're going on annual vacation. And then the court will not resume. Again, coupled with the fact that there will be international bar conference, so some lawyers may be attending. So therefore, the defense counsel, the lead defense counsel, says he's attending graciously. My lord said, okay, that's fine. We will now adjourn the matter to November 14, by which time annual vacation must have been concluded, and then those who also have participated in the IBA also must have returned, and then the matter will continue. I think that is exactly the position of the matter today. My lord noted that today's application, the ruling that she gave today, made it the 20th application, interlocutory applications that defense counsel keep bringing. If you believe strongly that you have committed, you've not committed the offense for which the prosecution is alleging that you have committed, why not submit yourself to the trial? Let the court determine it one way or the other. Then you go scot-free if you are not guilty. But if you are guilty, let the law too take its course. And that's exactly what we are saying. But unfortunately, they continue to delay the course of the proceedings. And we inform the court that justice delay is justice denied. And the prosecution is not ready to continue to condone the application, interlocutory applications of the defendant. So I think that is exactly what transpired in court.
Well, and next line of action is clear. The judge had advisedly struck out 8 out of the 15 count charge, in spite of the noise that the prosecution was making, that all the counts were strong. But what we did was to appeal against the remaining 7 count charge to the Court of Appeal. Don't forget, it was done successfully in the case of FRM versus Senator Bukola Saraki. The Code of Conduct Tribunal had discharged him and acquitted him on all counts that were before it. The Court of Appeal, upon appeal by the prosecution, the Court of Appeal retained some of the counts. Agree with the Code of Conduct Tribunal on some of them that were discounted. Saraki appealed to the Supreme Court. And the Supreme Court said, no, you can't oppose some and remove some. So the Supreme Court finally set free Saraki. That is the fate, by the special grace of God, going by Lamentations 3:37, that I see happening in this case. Who is it that speaketh, and it cometh to pass, if God has not commanded it? So what we have done is that apart from appealing, we have also timeously compiled the record of proceedings and sent to the Court of Appeal. And the appeal has been duly entered at the Court of Appeal. Going by Order 5, Rule 10 of the Court of Appeal rules, this court, Federal High Court, ceases to have jurisdiction over the matter. Because there can't be 2 Obas or 2 Ezes or 2 Emirs in one palace. The Federal High Court cannot frontally confront the jurisdiction of the Court of Appeal. So once a higher court has been seized of a matter, then the Federal High Court will wash his hands off that matter like Pontius Pilate did in the Bible. And the judge again today advisedly agreed with us that the appeal haven't been entered. Indeed, we have even filed a brief of argument to show how serious we are. We have even filed a motion dated 11th of October 2022, urging the Court of Appeal to grant us Nnamdi Kanu accelerated hearing, because we believe in the appeal. It is not a small screen appeal. It's an appeal we believe that it will settle this case once and for all. And as usual, the prosecution was trying to argue that, under Section 406 of AJA, under Section 492 of AJA, you are not to stay interlocutory proceedings. That is not the law. The Constitution is supreme. And by virtue of Section 1, subsection 3, any section of AJA or any act of the National Assembly that is inconsistent with the provisions of the Constitution is void, null and void to the extent of that inconsistency. If AJA, of course we know the Supreme Court has already struck down many sections of AJA. If AJA frontally confronts Supreme Court decisions up to this year to the effect that jurisdiction can be raised at any time, even at the Supreme Court for the first time, then how can you be talking about AJA saying that, AJA says you cannot appeal on interlocutory matters? How dare you say that? What AJA is trying to say is that even though we have attacked the jurisdiction of the court by saying that she has no jurisdiction to try the remaining 7 counts, what AJA is saying is that Justice Binta Nyako should first go ahead and try the whole matter. And then, at the end of the day, take a decision when she's delivering her final judgment. Take a decision on whether or not she actually had jurisdiction to try the matter in the first instance. So, ask yourself, even for laymen. If she never had jurisdiction to try the matter, what have we been doing for about 5 years now? It means that you would have wasted your time trying a case in which you have no jurisdiction, and you are now finally ruling on the day you are delivering the judgment that I have discovered I have no jurisdiction. Law is not, even if law were an ass, it is made for man to use reasonably. And law this time is not an ass. So I've told them, I said, save your gunpowder, let us go to the Court of Appeal and argue this point. Whether AGIA can overrule the Constitution, whether AGIA can overrule Supreme Court decisions, which continues to maintain that jurisdictional issues such as we have raised before the Court of Appeal can be raised at any time, even for the first time at the Court of Appeal and the Supreme Court. But in our ruling today on another issue that we had argued in May, which was that the bench warrant she had issued in 2019, was wrongly issued because Nnamdi Kanu did not jump bail. You jump bail when you leave voluntarily. Nnamdi Kanu was enjoying his bail, fulfilling all the conditions granted by the court, until the 14th of September 2017, when Army, under the pseudonym of Operation Python, invaded the home of Eze Kanu, the traditional ruler of Afaraoku, Ibeku, Umuahia, Abia State, leading to the gruesome murder of 28 innocent Nigerians. It was in the heat of that moment, fortuitously, Deus ex machina, by the intervening hands of the God, that Nnamdi escaped with the whiskers. He managed to escape. And he told me how he escaped. He himself cannot even realize it. You are saying a person who escaped certain death jumped bail? Like H.K. Abiola would say, he is only a madman that stands in front of a moving train. He will be crushed. You don't stand in front of a moving train. So we now told the court that Nnamdi Kanu did not jump bail. So issuing that bench warrant was wrong. And we filed our motion to that effect on the 1st of April 2019. But unfortunately, the judge apparently did not capture the date it was filed. In our ruling today, she said we waited 4 years before filing that application. That was not correct. We actually filed that application as soon as she granted that bench warrant on the 1st of April 2019. But she didn't see that. I think it was a genuine mistake of the head, not of the heart. If she had captured that date, she would not, because the entire ruling, and of course she said we could come back with more facts if we have more facts. Just as she also said we could come back with more facts for Nnamdi Kanu's bail. She did not totally reject Nnamdi Kanu's bail. She said we could come back for the bail by providing her facts to show that Nnamdi Kanu did not jump bail. These are the facts we are mentioning now. And if she had addressed her learned mind to the fact that this application was actually filed on the 1st of April 2019 and not a fresh application filed 4 years later, she would have ruled otherwise. Because of that, because these are matters of law and the liberty of a citizen is at stake under Section 36 of the Constitution, we are again appealing against that ruling of today because it was an erroneous ruling based on facts that were not before the judge. Now, on the other issue, which I saw trending, Mr. President, General Muhammadu Buhari, President Muhammadu Buhari, during the side talks at the 26th Commonwealth Heads of States Conference that took place in Kigali, Rwanda, also made the same point that Nnamdi Kanu has to escape explain in his trial why he did not want to intervene, why he jumped bail, went outside Nigeria, and started saying awful things, to use his words, against Nigeria. That was his position. I think Mr. President, with all due respect, was again misled by his advisors, particularly the prosecution, because this is the same position they have been maintaining, which they must have sold as a dummy to Mr. President. Nnamdi Kanu did not jump bail. As soon as he landed, first in Rome, he deposed to an affidavit in Rome that I have managed to escape here. This is why I escaped here, because they wanted to kill me. When he got to Israel, he deposed to another affidavit that I have managed to come here because I ran away from home after they tried to kill me, and they killed 28 Nigerians. They invaded my father's royal palace. These facts were placed before this court. And we have always put these facts, sworn affidavits, in Rome, in Israel. They are before the court. So, if a court ignores them, we have to test them at the court of appeal, because 3 good heads are better than 1 good head. So, Mr. President himself was again therefore wrong to say Nnamdi Kanu had jumped bail. Mr. President, sir, hear it now, sir, from me, loud and clear. Nnamdi Kanu never, ever contemplated jumping bail. He never jumped bail and had no cause to jump bail. He believes that Nigeria must operate under a system of social justice, equity, good conscience, mutual respect, and egalitarianism. But that if his people, the Igbos, are not being given an opportunity to have self-actualization and realization within the Federal Republic of Nigeria, and they are still being regarded, sir, as we call them, as a dot in the cycle, then they should be given the opportunity for self-determination. Self-determination is not a criminal offense. It is recognized by all international instruments. The United Nations Declaration of Human Rights of 1948, rights of indigenous people, social and economic rights, the African Charter on Human and People's Rights, the European Convention on Human Rights, the American Intergovernmental Convention on Human Rights. Every international convention recognizes self-determination as a human right. And when IPOB started until a Python Operation Python by the army, every Nigerian saw IPOB on the streets marching, blowing whistle. Pam, 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 pam. We are Republic of Biafra. They were never violent. They will wear their berets. They will be marching. They will be singing and dancing on the streets. They never went violent. It was the Nigerian state that introduced violence by going after an unarmed citizen of Nigeria. How do you deploy an armada of military weaponry against a young man like this that even in looks effeminate? He looks effeminate, even in looks harmless. And you are deploying that? Mr. President, sir, my own humble advice. I normally give my pieces of advice without requiring for payment. My humble advice, sir. This is a matter you can still intervene in. Nobody is saying you should intrude into judicial proceedings. I don't believe in it. But this matter can also have a political solution. Let no one deceive you about that. The Attorney General has the powers under Section 150 and 174 of the Constitution to enter a nolle prosequi, as he has found now that Nnamdi Kanu has no case against him. You are accusing a person of inciting people. You say he made radio broadcasts. From where he made the broadcasts, you did not tell us. Was it in the spirit world? Was it in the ghost world? Was it underground? Was it in the air? Was it in London? Was it in Ivu Kwenya Agenebode, my place? Was it in Kaura Namoda? Was it in Chibok or Dapchi? You didn't tell us when you said he made the broadcast. So, Nnamdi Kanu's broadcast, a noise he made somewhere in the ethereal world, suddenly made people to start fighting here. We have seen your lineup of witnesses. We didn't see 100,000 Nigerians lined up to come and give evidence that they participated in any violence because of, we didn't see. We have not seen witnesses. So, Mr. President, sir, you can still have a political solution because this matter is not fit for the court. Where you will know, sir, that Nnamdi Kanu has grown beyond himself is that he has become a metaphor for the Igbo man's struggle, the struggle of the Indigbo, the Alaigbo people, to feel wanted in the Federal Republic of Nigeria. That after General Olusegun Obasanjo took over the mantle of surrender from General Philip Effiong in January 1970, during the Civil War, when the Civil War ended, and General Philip Effiong handed over the mantle of surrender, and General Yakubu Gowon, the man who became head of state at the age of 32 years as a bachelor, an age where many of our children nowadays are still struggling in the university because of ASU strike every year. He pronounced the 3 R's: reconciliation, reconstruction, and rehabilitation. Ask the question, have the Igbos been reconstructed? Have they been rehabilitated? Have they been reconciled? If so, show me one single Igbo man in the security apparatus of Nigeria today. Why have you not allowed an Igbo man to be president? After Ekweme became vice president, vice to Alhaji Shehu Aliyu Usman Shagari. After General J.T.U. Aguiyi-Ironsi, Johnson Thomas Umunaku Aguiyi-Ironsi became head of state for only 6 months and was brutally murdered during the counter coup. So, when we're talking about social justice here, give it to a people. When you give social justice to the people, then all these tremors, all these volcanic eruptions, all this armed banditry, all these Boko Haram, all these kidnappings, all these murders, all these suicides, all these homicides, all these different types of sides, they will evaporate into thin air. It is because the Nigerian state is not practicing social justice and equity. It is because we are not practicing true federalism. It is because we are practicing a unitary system of government which does not allow for federative units to operate at their own pace and have their own self-realization. These are my few words to Mr. President as he winds up his administration. He has barely 11 months to go. Let Nnamdi Kanu go, just as Moses was telling the Egyptian Pharaoh, let my people go.